Mark Clough of Studio Lauro will deliver a speech, Current Competition Issues in the Financial Services Sector.
Thank you. Do I press the arrow? Just this one. Yes. Yes. Good morning, ladies and gentlemen. It is a great privilege for me to address this distinguished audience, and I'd like to thank Avvocato Francesco Lauro for giving me the opportunity to speak again at this wonderful annual conference on shipping and the law. I, for some reason, choose to talk about the frightening subject of competition law, and against the background of Fabrizio's very interesting presentation, competition law, I'm afraid, is perhaps yet another problem for the financial services sector, which in the shipping context will have an impact on the shipping business. Because, of course, when times are bad is when people like to talk to each other and try and share the problems and break competition law in the process. So I have just a very short period to frighten you again this year. And one of the main things I want to bring to your attention is what's happened in London, in the UK this year, with the Financial Conduct Authority. Because the Financial Conduct Authority has brought out some new rules, and you won't believe this, but under the regulatory rules, regulated financial services providers are required to report on a voluntary basis infringement of competition law. That's nothing to do with competition law enforcement, it's the regulatory enforcement. And if you get caught out not doing it, you'll lose your license. So if that's not a dramatic development, I don't know what is. And if I also point out that this applies to regulated entities, for example, a bank or a provider of venture capital, to their overseas activities where the breach of competition law is significant. Now, quite why this has happened, I'm not sure, but I think some of you will tell me it's just the same as what already happens in the United States. And I think that's what is the position. So in a way, that's one of my main messages of fright for today. But just to remind you that both the EU and the UK competition authorities still target financial services. Excuse me. You remember all the LIBOR cases that are going on, and we'll look at that in the context of joint ventures. But the other main area I want to emphasize is information exchange, because that is where it's very easy to get it wrong in all businesses, but in particular in the financial services sector. There's been a lot of what we call loose chat, which has ended up in high fines from maybe 10 to 30, 40 million euro. You remember last year, those of you who were here, that I mentioned the whistleblowing by Barclays Bank on RBS and how RBS was fined £30 million for effectively exchanging information in the context of syndicated loans. That, of course, is an area where shipping is still, I think, relevant, despite what Fabrizio said. I mentioned the FCA. There's also a new area of complication which is primarily of interest to lawyers, the double jeopardy risks, which I'll say a very few words about. The real problem is that there's not a lot of clarity. There's some guidance which I'll flag up for you. And my main final message is that all businesses, but in particular in the financial services sector, they must have competition compliance programs. And there are plenty of lawyers around who can offer that advice. Just to remind you, the Treaty on the Functioning of the European Union prohibits agreements that restrict competition law, but it does provide for an exemption. And these days, we have what we call self-assessment, which means that companies have to advise themselves if they think they've got an agreement or practice restricting competition, is it actually of overall benefit to the market they operate in? Does it share that benefit with their customers? And is it not eliminating effective competition in the relevant market? The other main rule is the prohibition of abuse of a dominant position, which is not likely to happen very often either in financial services or shipping. But financial services is an enforcement area, priority enforcement area, both at the EU level and in several member states, including the United Kingdom. Slightly complicated in the UK, there's no definition of financial services within the Financial Conduct Authority's remit. They effectively say in their guidelines that it covers all authorized and unauthorized financial services and all activities of regulated service providers, but also their unregulated activities. So effectively, the whole area of financial services is covered by UK competition law, at least if not EU. I mentioned joint ventures and information exchange as the two main areas that I wanted to look at, because that's where we have the problem of cooperation between competitors. Obviously, in financial services, there's a lot of cooperation between competitors. It's designed to improve efficiency and therefore to pass on the benefit in lower prices and charges to customers, which, for example, should benefit shipping lines in that context. But in specific areas of joint trading platforms and syndicated loans, we've seen problems arising, and indeed the risk of having effectively standardized terms between two or three otherwise competing financial providers with exchange of information on pricing, so there's no competition on pricing, and indeed even the general conditions of competition in the market. All of these will be condemned by a competition authority. There is not very much guidance available. At the EU level, there's a guidance note, if you like, on what are called horizontal cooperation agreements, which has quite a large section on information exchange. And if one is able to bring oneself within those guidance notes, then that's fine. In the EU insurance block exemption regulation, there are specific exemptions, automatic exemptions for in insurance pools, in particular reinsurance pools. And I would suggest that one could perhaps, by analogy, use the approach there in other areas of financial services, including banking. Information exchange. This is the real high-risk area because it's treated as a cartel, which, as you may remember, is the worst offense almost in competition law terms. And it's just, if people are talking between competitors, it doesn't matter there's no agreement. It doesn't matter that nothing happens as a result of this information exchange. If a competition authority gets to find out about it, it will have the right, I'm not saying it will, but have the right to impose quite significant fines. Now, this is not a financial services case, but the most recent case, March 2015, the Dole Banana case, as it's called, I thought might amuse you a tiny bit, although it's not very good news. Going back to 2002, there was what they called the Radio Banana, which was a sort of telephone gossip communication link between various competing banana importers and vendors in Europe. They discussed stock levels, leftover imported stocks, not sticks, at ports, anticipated demand and market developments. And indeed, they discussed the likelihood of price fluctuations. Today, one might expect that to take place through email and sort of online chat services that exist on mobile phones. But back in 2000, it was on ordinary telephones, Radio Banana. Now, the fine of 45.6 million euro was upheld this year by the European Court, despite 2 attempts to appeal that decision of the European Commission. So that is a very good warning to us all that there is a risk of very significant fines from a pure information exchange, which is called an infringement by object. In other words, there's no need to show any effect or impact. It's just by definition that will be treated as an infringement. And we also have, as you all know, I'm sure, in the container shipping context, the alleged price signaling case that's going on at the moment with the European Commission in Brussels. I was in Copenhagen the other day at a maritime law conference called EMLO, where Commissioner Vestager was talking, and the inside story was she had hoped to announce that this case had been settled, but it hasn't quite yet been, and I expect some of you in this room know more about it than I do, but it is apparently going to be settled, and I don't think there'll be any fines in that context, but that is a slightly esoteric version of information exchange. I don't want to bore you about the UK, and I've perhaps made my main point, but there is a lot of new stuff going on with the Financial Conduct Authority and the Payments Services Authority regulation in the UK. This is, the FCA, as we call it, has got what are known as concurrent competition powers, which complicates life because it means that they can enforce competition law as well as use their regulatory powers. This applies in practically all areas of competition law apart from merger control and what we call the criminal cartel enforcement, which is left to our Competition and Markets Authority. The effect of the Memorandum of Understanding on case allocation is that the FCA will now deal primarily with competition cases in the financial services sector, and it will it has an obligation under its rules to give priority to applying competition powers before applying regulatory powers. So there's a risk of what we call double jeopardy, ne bis in idem, and there's a lot of case law now coming out of the European Court of Justice based on what are called the Aalborg-Portland case principles, which say that if the facts of the case are identical, the parties in the case are identical, and the area of regulatory policy is the same, then there should not be 2 fines. So you could have a regulator, for example, in the telecoms industry, imposing a fine for a breach of regulatory requirements, and then the competition authority imposing another fine for more or less the same activity. The trouble is that the European Commission has taken the position that competition law is by definition, if you like, a separate regulatory area to any form of other regulation. And so far the European Court has agreed with that. The latest case which has just gone to the court is called the ICAP case. This is about the Japanese yen LIBOR benchmark manipulation by an intermediary in this case, money broker, and that's going to raise all these issues again. But I don't think there's a great expectation that that law will change. And finally, the position, as I said at the outset, is fairly unclear in this general area, but the 2 main things we must focus on are information exchange and horizontal cooperation, where we do get some guidance in the guidelines and the insurance block exemption regulation. But I can't say it often enough, all businesses need to have competition compliance programs. Some would be very limited in their scope, depending on the size, but for big businesses, they need to be big. Thank you very much.